Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner. With me today is Senior Associate at MBK Chapman, Sam Kill.
Hi,
Sam,
Mike.
Thanks for coming back.
Thank you, sir.
Here we are again. We're now on episode 5 or part 5 of a 6-part series on neighbor disputes. And today we are going to ratchet up the emotional index because we're going to dive right into the category of neighbor-to-neighbor conflicts that involve the police often and very emotionally charged. We're talking about harassment. We're talking about surveillance, invasion of privacy. We're talking about defamation, and we're talking about assault and battery. So basically, when neighbor drama turns personal.
Right.
Okay, so we're going to be talking about a lot of very serious and emotional situations today. Some of you might have experienced some of this. If you have our condolences, because it doesn't get, this is probably amongst the worst type of thing that we deal with, because some of this can be, I mean, when it rises to the level of assault and battery, we could be talking about real harm.
Very serious.
In jail time and other things like that. So it can become very, very, very serious. And so that's today, okay? But it is a type of neighbor-to-neighbor dispute, and it does happen, and we have it in our office. We see cases like this, and it's a shame, but it's real, so that we got to talk about it, okay? So today, I'm going to talk about what qualifies civil harassment, touch base on that, okay? I'm going to talk about when you can get a restraining order and when you can't, okay, what it takes, how to challenge illegal surveillance, that is, if somebody is invading your privacy, what you can do about it, okay, what conduct constitutes defamation, and so what is defamation, what constitutes defamation, and I'm going to also talk briefly about a caution in California when it comes to defamation claims, even when they're completely 100% valid. So we're going to talk about briefly the anti-SLAPP statute, and then how to respond, how to deal with when you're being harassed, or when you're having your privacy invaded, or when you're being defamed. What should you do? And then, of course, we're going to go into what constitutes assault and battery and how to deal with that as well. So let's start with civil harassment, okay? Give me a 2-sentence dissertation as to what civil harassment is, or what it's not, and I can jump in and tell you what it is. You take.
Well, let me just kind of go with some unprepared remarks. Civil harassment to me constitutes something well beyond a mere annoyance. It's an overt act or pattern of actions and conduct that severely is upsetting. It's outrageous oftentimes using an objective standard. It can cause severe emotional distress or anguish in the victim person receiving or being subject to that treatment. And it really rises beyond what we've covered thus far in terms of a typical nuisance scenario. So this can be an intentional act or a pattern of actions or conduct. It could be as short as, a few days or cross into weeks, months, and in some cases, even years.
I think you hit it on the head.
Right.
Actually, you did a very good job of describing the statute. I mean, there is a statute. It's CCP 527.6, right? And the statute defines harassment kind of in 3 ways, in 3 parts. It says basically that it's harassing, threatening, or intimidating conduct that has no legitimate purpose and that objectively impacts your emotional state or causes emotional distress.
Right.
So if you and your neighbor frequently exchange, bad words with each other because you just don't like each other,
no,
probably not harassment, okay? If your neighbor, every time they see you, if your neighbor flips you off, it's not harassment, okay? But if your neighbors start, let's say your neighbor knows that you've got little kids that go to bed early, and your neighbor starts blasting music at 8 o'clock every night for like 2 hours, okay? That could cross into harassment. If your neighbor puts things on your driveway, nails or other things on your driveway, in addition to other things, there are other torts involved there, destruction of property and sort of thing, but that would be harassment.
It's very deliberate, and it's targeting you.
And it's
repetitive.
Right, exactly. So it's harassment is one of those things that's kind of hard to define sometimes because it's easy to define when it definitely is harassment, right? And it's easy for us to say when something definitely isn't harassment.
Right.
The hard part is deciding when something might be harassment, all right? Because then it's, right? It's an objective standard, but objective isn't necessarily crystal clear. There's no bright line for what objective is or what objective isn't. So on either side of the bell curve, it's easy. But it's the middle part, which is really most of life. That's the hard part. And so that's when, to determine if you're being actually harassed in the legal sense, not in the colloquial sense, that person's harassing me.
Right.
You're going to need a lawyer. You're going to need somebody trained in this area of the law. So you'd want to come to us at MBK Chapman because we can help you with that. But I can't tell you how often you hear or how I hear, I'm being harassed. I'm being harassed. And we talk about the specific conduct, and it's harassing conduct colloquially, but it isn't harassment under the law.
Right.
It's just not. But then there are those cases where, it is. And that's when it's actionable, and that's when we can step in and help. So let's talk about stepping in and helping, okay? First of all, if the harassment is to a point where it really is legal harassment, you can actually get a restraining order.
Absolutely.
Okay?
Right.
Restraining order is a very big deal. A civil restraining order, and we're not talking about the restraining order that one would get in a typical HOA case when the judge is gonna order the HOA to not cut your tree down when they're threatening to do it, because we go in for a restraining order to prevent them, or order them to do something. You must hold another election because your first election was illegal. Those are restraining orders. It's not a civil restraining order in the sense that we're talking about. We're talking about a restraining order on an individual, on a person. Those restraining orders are obtained through a set of laws in the civil procedure, Code of Civil Procedure. And if they're granted, there are some severe consequences to the person receiving them. Right. For example, you can't have possession of guns in the state of California if you're under a restraining order. Okay, you're more likely to be pulled out of line at an airport if you have to be one of the ones they do a check on and they run your name, and that comes up. You might be pulled aside for a quick interview. Okay, you might not be able to attend a function at your kid's school or volunteer at the school, for example.
Well, you're court compelled to stay away from that person.
And of course, you have to stay a certain distance. And of course, if they're your neighbor, the court can't make you sell your house because you're going to be within 500 yards. But, the point is it's a very big deal. And so because it's such a big deal, the courts are supposed to treat it much more solemnly. And so you got to have really good evidence. And that's where we're going next is, let's say you get to the level of harassment, okay? You come to us. We're going to want to see some documentation. We're gonna say something today. I'm gonna say it right now, and I'm gonna repeat it for every topic we talk about today, because documentation is one of our mantras. The court does not want to see a situation that is he said, she said. Right. The court wants evidence. It's not enough for you to say I'm being harassed, because we hear that all the time, and then we go down to the meat. It's not really harassment. Court wants to know. Oh, that's great. Thanks for telling me. How are you being harassed? And you have to be specific. Okay. And it's not enough for, one time he did this. That's not harassment. Harassment is systemic.
It's a serious charge, so you have to be
seriously prepared.
Seriously well prepared and substantiate those contentions.
And if you want us to do our jobs and help you with that, you've got to give us the tools.
Right. Because
if you don't give us those tools, we're not going to be able to do very much. Okay. And so what are those tools? Well, we always say this, written log. What is a written log? Date, time, and description of what occurred. Okay. My neighbor threw dog poop onto my driveway. And so you have the date, time, approximate time, or at least the date, and the description, threw dog poop in my driveway. And just catalog it every time it happens. He threw it over my fence on this day, threw it into my pool on this day, threw it on my driveway on this day. Told me that if I didn't watch myself, that he would be, a veiled threat, not a direct threat, but a veiled threat. Things that make you really, they start to affect your actual ability to enjoy your property. That's when it starts to rise the level of harassment. Log it. If you've got video, get video. Give it to us, or even still pictures. If your neighbor starts, pull your camera up, start videotaping. If you've got your camera up, you don't have to notify them under California's two-party rule that you're videotaping, because it's obvious you're doing that. Everybody knows what this means. Okay, and you're holding a phone up. They know what that means. You're being videotaped. So by all means, video. So we got log, we got video, we got pictures. If you have a witness, get a statement, a sworn statement. All they got to do is say it under oath.
Right.
I, John Smith, declare that and then have him describe what he saw. I saw this, and this on this date. I say these things, or I make these declarations under the penalty of perjury, under the laws of the state of California, on this day, in this county. Sign the name, good to go. Or have us prepare something. Witness statements under oath, great to have. And if you can't get them under oath, then get the witness statements, but get them in writing. Okay? So those are the kinds of things we need to see. All right? If it rises to the level of harassment, can you file a police report?
Absolutely.
Sure.
Absolutely.
Especially if there's some other crime involved, like destruction of property. If they go and throw something into your pool, that is a crime. It's also a trespass, isn't it?
It is.
They throw something over the fence into your yard, they've caused a trespass.
If anything's damaged or broken, vandalism.
Or you've got to have the pool guy come and somehow clean that up, or do something with the filter, or empty the pool, refill. You know what they do at public pools when there's a poop accident, right? Yeah. You gotta shock it, or whatever it is you do. Send an invoice, okay? But I would do a police report,
right?
Okay, absolutely file a police report. If there's any kind of if it's come to the point where you're seeking medical intervention, you go to a psychologist or a social worker or a psychiatrist or a therapist of some sort because of what's happening, get copies of that medical record. You might want to use those, okay? That would be helpful. And of course, any correspondence between you and the neighbor or you and the HOA, we want to see that, okay? So, judge wants to see evidence. They don't want he said, she said, so make sure you get that evidence, okay? Now, we'll ratchet up a little bit and we'll move into surveillance and invasion of privacy. Okay? Surveillance is just that. You're being surveilled. You're being watched. Now, you have a right, and your neighbor has a right, to have cameras up to protect their property. For purposes of security, people have a right to protect themselves, their family, and their property. And Ring cameras are very common now. But even cameras up on the eave, or cameras, as long as it's on your property, those are among the best ways to ensure that A, you can get evidence if something happens, and B, you can kind of keep an eye on what's going on, okay? That's all well and good. Everybody has a right to that. What they don't have a right to do is violate your privacy rights. Where you have an expectation of privacy, and that's a phrase that you're going to hear a lot when we talk about this, where you have an expectation of privacy, they cannot invade. You have an expectation of privacy in your home. You have an expectation of privacy in your car. You have an expectation of privacy, even if you're in public, but there's a conversation that's private between you. Right. You have an expectation of privacy that you're not being recorded by sound recording. Video recording would be fine in that situation.
All reasonable, by the way.
Right.
Yeah.
Okay. What you don't have an expectation of privacy in is in public or in the common areas, except, again, for private conversation. Okay. But taking video of you having a private conversation is not violating your rights if you're in public or you're in the common area at the time. So if you want to have a camera facing out to the sidewalk or the street, that's perfectly okay. But if it has sound attached and you can hear conversations, that could be a problem.
Right.
They can't have a camera pointing into your home, through your window, through your front door, or into your yard so that they can watch your kids play or watch you lay out. They can't do that. That is illegal. Okay? And people do that all the time.
It's shocking to me that people do that, but it happens.
They do it because it is disturbing.
Right.
Nobody likes to be videotaped. We did an experiment in high school. I don't think I've ever told you this story. We did an experiment in a sociology class, AP Sociology.
Okay.
12th grade. And the experiment was quite simple, and it was fascinating, and it was so much fun. We have 35 students or so, whatever it was in our class. Okay? It was AP Sociology. And our classroom was on the bottom floor of one of the buildings. And of course, there are people, especially during passing period, when the class is over, there are lots of people walking outside. Like if you look through the windows to the outside of our classroom, there's people walking back and forth right there within 3 or 4 feet of our window, right? Sometimes people will stop because these windows are reflective. They'll stop and they'll preen their hair or whatever, but that happens. And a lot of the classrooms, they kind of turn the shades up, right? So what we did is right when the bell rang, we opened the shades. We pulled the rope so that they went all the way up. Now you don't have the slats there. And all 35 of us stood at the window with our faces pressed almost against the window and stared out at everybody walking by. I can't tell you how many people stopped and looked and like we're really uncomfortable and like stood up, stiffened up and then kind of just got out of there as quickly as possible, right? Just having 35 people staring at you. It's not normal. It's an extreme example, but we're kind of invading their privacy of their private thoughts or their private conversations. And all of a sudden you have these people, you're being stared at, you're being watched. People don't like to be watched.
No. Yeah.
Okay. When, it's one thing to be in public and nobody's really watching anybody, but if somebody's focused on you, that's uncomfortable. Mm-hmm. Well, imagine if they're focused on you in the privacy of your own home. They're invading what's supposed to be your safe space in life. Mm-hmm. That's not cool.
Frowned upon. Yeah, absolutely.
Yeah, it's very much frowned upon. Mm-hmm. So under Civil Code 1708.8, that's an invasion of privacy. That is a civil tort. Okay. It's actionable. You can sue somebody for invading your privacy. So if your neighbor has a camera pointed in your yard and he or she is watching you and your kids, you can sue him for that. It's illegal. It's also creepy. Okay. But it's also a crime. Penal Code 647 makes it illegal to do that. Now, there are a few penal codes that are involved, but that's one. Okay. Mm-hmm. It's a criminal offense, which kind of leads to that next issue. They can't invade your privacy. So what do you do?
Again, our mantra, you document, you report.
How do I document?
Well, you take, with cameras, you specifically take photos of the camera and the vantage point. I mean, you could do it from the location or the side where you have a reasonable expectation of privacy. This could be your bedroom, could be the immediate curtilage or patio area of your home.
Or your yard.
Or your yard, where they have no legitimate business looking into or intruding into. And you snap a photo of the camera.
And the lens especially.
And the lens especially. And, you can take video footages of that if there's any other conduct incidental to the camera.
Let me touch on what you just said.
Yeah.
You were saying go to the place where you have that privacy. You go to your yard or your curtilage or the bedroom window, whatever it is.
Yeah.
And I think what he said, maybe you didn't make this point as well as I think the point you meant to make was if you're standing where you're supposed to be in private and you point your camera directly at their camera and you're looking at the center of their lens, it's very likely that lens is looking at the center of your lens, which is right into your window.
Yeah, that's a good point. Yeah.
Or your yard.
Right.
That's one of the ways to prove that their camera is directed in the wrong way.
Mm-hmm.
Okay, because it shouldn't be that way. Okay, something I've told clients to do is I say, because there's no expectation of privacy in the camera itself, I would zoom in on the camera and see if I can get a make. Okay, and then I would Google that camera and look at what its functionalities are. If that camera has a certain field of view or detail at a certain distance.
Or captures audio.
Right. You can see, you can use that evidence to show that, this isn't just, even though I'm 50 yards away now, this is actually getting details that it shouldn't be. But if the camera is limited to, let's say, 10 yards, and you see that, then maybe you're okay. But I would certainly grab that. But I agree. Video and pictures, absolutely. Mm-hmm. Obviously a log. Less important in this case is, having evidence like video and photography is better. But also, you can actually use a mirror too. There's a trick. You can Google that. I won't go into the details, but there's a way to use a mirror to help find out what angle a camera's looking at. I would certainly communicate with the HOA, wouldn't you?
Absolutely. 100%.
Make a demand. Get involved. Right. Hey, HOA, get involved. He's violating my privacy rights. That's a nuisance. It's also an invasion of my privacy. You need to tell him to cease and desist. You need to tell him to remove the camera, relocate it, or shift its direction. Okay, the camera might be in a place that it's permitted to be, and maybe it just needs to be canted downwards, right? Mm-hmm, mm-hmm. So that it's looking at that person's property and not into your property. That would be okay.
Right.
Okay. Now, is it illegal if the camera's pointed in a direction that's looking at their property and has incidental view of yours?
That's not illegal per se, but it does need adjustment. So to the extent it can be adjusted where it serves their legitimate purpose, but also protects you, that's what needs to happen.
Right.
Yeah.
The camera can't be picking up private stuff, even incidentally.
Right.
Okay, you just can't do that.
Right.
A camera can always be directed more specifically. Mm-hmm. It can always be directed in a way that cuts out your situation. Now, no homeowner should be using a camera as a means of security, other than a Ring camera, which is only activated when it needs to be activated, sound-wise, that is. No camera should be taking sound 24/7. Mm-hmm. The Ring camera's sound kicks in when it's being used, right? It's always filming, but you can talk through it, right? Mm-hmm. No camera, there's no legitimate security purpose served by sound. The reason sound is dealt so differently is because you can shift a camera's field of view down by moving the camera so that's focused, let's say, down as opposed to toward your yard. But sound is 360 and goes outward, right? You can move the camera and that wouldn't affect the sound. They don't have a right to listen to what's going on in your yard. Your kid frolicking or singing or conversations that are occurring. They're not allowed to take that down. That's private. Period. End of story.
Absolutely.
Okay. Yeah, you could go inside and talk, but you shouldn't have to. Okay. So there's no legitimate purpose served. I would argue any sound other than intermittent sound, like a Ring camera, any sound does not serve the needs of security, and it should be barred. And I think you'd win that.
Agreed.
Okay. So document, but do act. That is an issue. Okay. So next on our list, now we move into defamation. We move into when gossip and words become a weapon.
Right.
Okay. Sam, is it defamatory for me to call you a jerk or a putz?
As much as I would like for that to be the case, no, that's not defamatory.
Is it defamatory for me to cuss at you when I see you, to flip you off?
No, it's not.
It's not. It's not defamatory. No. Defamation is a statement that's untrue and it's made about somebody else to a third party.
Right.
So if I'm talking to you alone and nobody else is around, it's not going to qualify.
No.
Okay, it has to be a third party.
Unless that's recorded and then disseminated.
Well, that's different. Right. Now you have third parties.
Exactly.
Okay.
Yeah.
But my scenario didn't have that. It's just us. But it has to be a statement that's untrue, and it has to be a statement that it can't just be mere opinion. It can't just be my analysis of your personality. For example, you're a jerk. You're an a-hole. You're a lousy friend.
Right.
Or you're a lousy neighbor. Because it's not illegal to be rude.
Right.
And it's not illegal to be mean. It's illegal to defame. And defamation comes in two large categories. It can be written or it can be vocal or verbal. When it's written, it's called libel. And when it's verbal, it's called slander. They're both defamation. If I call Sam, if I say, Sam, you are a fraud and a liar and a cheater. You are a crook. You steal people's money. Now, if that's not true, if I'm lying, that's defamation.
So long as you have third party.
So long as I'm saying it to somebody.
Right.
If I accuse somebody of something, I accuse them of doing something or not doing something they were obligated to do, or I accuse them of committing a crime, if it's not true, it's defamatory. The truth is the ultimate defense, okay, to any defamation claim. So mere opinion, insults, don't fly. That's not going to be defamatory. It has to cross that line, okay? Now, unfortunately and not unfortunately, I don't want to weigh in on whether it's good or not, but this is the way it is in California. There are places and situations where somebody can defame you, clear-cut, crystal clear defamation, but it's privileged under the law, completely privileged, meaning you can't go after them for defamation even if it's defamatory. One good example of that, and there's a statute on this, it's Civil Code, I think it's Civil Code 47. I'm doing that from memory, I could be wrong, I think it's 47. If you're in the midst of a lawsuit, for example, and in an actual lawsuit or a complaint or in an answer, you are declaring certain facts or you're alleging certain facts, it doesn't matter if they say those things with malice, with knowledge of their untruthfulness, you can never sue them for defamation. You can go after them for malicious prosecution once you win. You can do that, but you can't go after them for defamation. So in the context of actual litigation. And then there's also another one that is relevant to HOAs, and that is the courts have held that HOA open meetings, those board meetings that everybody goes to, and you're yelling things back and forth, when you're talking about things that have happened or you're speaking at a meeting, it's very likely that the stuff said during there is going to be privileged because HOAs are seen in some ways as quasi-governmental, and that's considered a governmental body arguing law, right? It's treated that way by the courts. And so you could run into a problem if you're trying to allege defamation in the context of an open meeting. But where I'm going with this is there's a doctrine in the state of California you got to be very careful about. Even if you've been defamed and it's actionable, that is, it's not privileged, it it doesn't mean that you're not going to face an expensive challenge. And there is something in California called the anti-SLAPP. And SLAPP is spelled SLAPP, and it stands for Strategic Lawsuit Against Public Participation. Now, that statute, I won't go into. I might do a show on it by itself in the future, and I'll go into its history and why it began. But it let's just say it's kind of flipped its original purpose. But right now, it is used as a powerful sword and a weapon against people that sue for defamation or for malicious prosecution, for that matter. You rarely see a defamation case filed when there's not an anti-SLAPP that's filed also. What an anti-SLAPP does, it stops the litigation cold until the hearing is held. And during that process, there's no discovery, there's no nothing. Case is frozen. What the person who files the motion, it's always the defendant, the one being accused of whatever, okay? Mm-hmm. So if they're alleging that I defame them and I sue for defamation, they bring an anti-SLAPP to challenge that, right? I can get over the SLAPP. In other words, the judge could deny their SLAPP and then allow the case to go forward. But the judge could also grant their anti-SLAPP. And if that happens, the case is over, you lose, and you pay their attorney's fees. And attorney's fees for an anti-SLAPP motion can be $35,000, $40,000, $50,000 just for one motion. It's a very big deal. Now, a lot of lawyers don't know about them. A lot of lawyers, more incompetent ones, don't even ever bring them. So we've gotten away with doing that. And it doesn't mean don't file it. If you've been defamed, file it. Because again, we'll get you over the SLAPP. The problem is the way the statute reads, if they bring an anti-SLAPP and lose, that is, your case gets to go forward because it's legitimate, the only way the court will award them, the only way the court will allow you your attorney's fees is if their anti-SLAPP motion was frivolous. If they win it, they get them no matter what. But if you defeat the anti-SLAPP, you get it only if their motion was frivolous. Now, in many cases, when we have evidence, again, backing stuff up, if we have video evidence or pictures of the defamatory conduct, or we've got written evidence, right? We've got pictures of the conduct of the letter that went out or the emails that went out about me or whoever, and they bring an anti-SLAPP just to screw with you, we can often prove that's frivolous because look at all the evidence they had. It was frivolous to bring this when they knew that we had at least a legitimate basis to bring a defamatory conduct lawsuit, right? Exactly. So you should always go after somebody if you've got real defamation. The time to be cautious is when you're not sure whether it crosses the line. That's when you need to be more cautious and decide whether or not you want to risk an anti-SLAPP. And if you get over it, whether or not it was worth it, okay? So keep that in mind, but it's something I thought I needed to bring up, okay? So we want evidence. The more evidence, the better. That'll help you on an anti-SLAPP. It'll help you in your case. Mm-hmm. Cameras, video, a log, written examples of the defamatory conduct, all that. Anything you can gather.
Witnesses.
Keep it. Witnesses, thank you.
Yeah.
Witnesses. Keep it. Mm-hmm. Great stuff. Now, just remember, not everything offensive qualifies. It's got to be real. Mm-hmm. So stay tuned for another episode where I talk about defamation in particular. But we want to have as much evidence as possible. You agree?
Every single time. Yep.
Okay. All right. Now let's move into something that's, I think, even more serious, and that's when we move into assault and battery.
Yeah.
Now, fortunately, we don't see this every day, do we?
No, we don't.
Not every day.
Luckily, yeah.
But we have seen it. Mm-hmm. We've seen it. I've seen it lots of times. And I know Sam has seen it several times. We see it often enough where it's always present, okay? So let's talk about the difference in the law between assault and battery. Enlighten me on assault.
Well, assault is the intentional act of putting someone else in an apprehensive state. So you're threatening them, no touch and contact, but just the overt act of the possibility of an imminent contact or harmful conduct.
So if I raise my fist and I move forward like I'm about to hit you.
Right. That's assault.
That could be
assault.
That could be an assault.
That's imminent. That's puts me in apprehension.
It's not assault if I'm on the phone saying I'm going to hit you right now.
No.
Because it's impossible for me to hit you right now.
Correct. Hasn't happened yet. Right.
And I can't do it. I'm on the phone.
Exactly.
Unless I'm on the phone right next to you. I meant if we were at a distance, if we were a block away.
Or you swing the phone handle.
Yeah, exactly.
Right.
That would be assault, the swinging of it. You often hear assault and battery in the same sense. Oh, he's guilty of assault and battery.
Right.
Well, they often do work together. If I make it clear, if you see my fist coming toward your face,
right,
there's the assault. As soon as my fist makes contact, there's the battery.
Right.
It's the unwanted touching
Right.
that becomes the battery.
Harmful
So
and
assault and
offensive,
battery is you saw me swinging at you and then you felt the hit. Battery with no assault might be what? I hit somebody on the back of their head.
Exactly.
You know,
They didn't see it coming.
Somebody punches you in the back of the head, you didn't even see it coming.
Right.
That's a battery, but there was no assault. Okay? If you heard them and you turn around at the last second, now you got assault right before they did it, right? That's assault and that's battery, okay?
Right.
And those are both illegal,
Indeed.
okay?
Civil and criminal.
But they're civil torts and they're criminal acts,
Right.
which means whenever you get in the criminal, like we talked about defamation a minute ago, typically not criminal, right? No penal code section, you're not calling the police on that necessarily, unless it's mixed with other things.
Exactly.
Right? But assault and battery, police are going to get involved. We'll talk about that in a second because you absolutely want those police involved, okay? But let's talk about the civil part first. It's illegal civilly. It's actionable civilly. It's also almost 100% a violation of at least one provision or more of a governing documents.
Nuisance conduct.
At least.
Right.
At least. And 99% of CC&Rs in California have nuisance provisions. Okay? So, Sam, walk me through. I've been assaulted and battered. What do I do?
Well, especially in cases of involving battery, I would first and foremost notify law enforcement.
Immediately.
I mean that's part of your documentation, part of your evidence gathering, case setup.
Call the police.
Call the police if there's any injury or even in some cases damage to property. And I don't want to digress into that. You obviously, in a case of any personal injury, you go to the ER or urgent care.
Well, if he pushes you into something and it breaks on your property, I would take pictures of that too. Yeah.
Take pictures of that, or ask someone else, a family friend, a witness, to take photos of that. I would also
how about bruises or cuts or something on you?
Take photos, take video recordings. If it's date and time stamped, even better. Have someone else take it. Line up and secure witnesses. These could be acquaintances or it could be strangers, so
Somebody
that you have the
standing
contact
around.
information.
Yeah.
Exactly. And then, most importantly, if you need to seek medical attention, go do that.
Right. Very much so.
Time can be of the essence, and you want to make sure that you're not derelict in doing that step.
If you're severely injured, then the first thing you do is go to the emergency room. Okay. If the injury is such that you can, you can wait the next day to see your doctor, but you're not going to go till the next day. Definitely call the police first. Okay.
Absolutely.
But you do need to make a police report. You absolutely want a file number.
And then that's not mutually exclusive from you also notifying in due course your HOA.
Right.
Your property.
That should be
manager.
last. I mean,
Right.
you do that when things are stabilized.
Exactly.
Okay. First of all, I guess the first thing should be is get yourself out of the danger. Get yourself out of the situation. Right. If you're outside, get yourself inside your house. Then call the police. And then if you need to go to the hospital, get somebody to take you. Or if it's something you can do the next day, like seeing your doctor, then arrange for that. So I guess get yourself out of the scenario. Then get the police involved.
That's a good one. Yeah.
You must get the police involved if there's ever an assault and battery. Always, every time, without exception. If it rises to the level of criminal and civil conduct, it's both. Get the police involved. I want that police report. Okay? The police will interview different witnesses, including the perpetrator, yourself, and anybody else that sticks around. And then the police will make a report, and that report can come to you. You want to urge, once you collect all your data, I would also urge the police department to turn that over to the district attorney's office. I would be very, very, I would be that squeaky wheel. I want prosecution. I'd be writing the DA's office, like once it got transferred over, I'd be writing them every day. I want prosecution.
And that can really have heightened probative value, but also really add to your credibility and bolster your case for a possible civil harassment restraining order.
Absolutely. And assault and battery with any kind of evidence whatsoever is probably the best thing you can do to support getting a restraining order. I mean, as the quickest recipe for a restraining order, we talked earlier. Yeah. I think we talked about it in, did we do it in this episode or last episode?
I think it was last episode.
Last episode, we talked about restraining orders and how big a deal they are. But assault and battery, that's usually exactly what they're awarded for. Okay, so you stand a good chance of getting that, and you do want that because if a person's gone to the point where, without, being provoked to the extent to actually lay hands on you, that they've done that, then they're capable of anything, and you don't want them in having a weapon. So certainly, police report, restraining order, and for that you're going to need a lawyer. You're going to want to come to us at MBK Chapman. We'll help you get that restraining order. Okay, so go to urgent care if you have to. Do that first if it's an emergency and you're like gushing blood, and then you call the police from the emergency room, right? They'll come to you. Don't worry about that. Or if it can wait, you do the police first, but you get that done. When you're stabilized, things are you're out of the emergency room or you're done with the police, then you send an email or a letter, typically an email to the management company or the board, discussing what happened, name names, where was it? I was at my house, he came onto my property, whatever it is. Give the details. And then say that you will follow up and provide give any evidence you might have. Here's some pics that I have now. Here are the names of the people that were there. I haven't secured statements from them, but they said they'd be willing to talk to you, whatever. And then I would close the email by saying, I will follow up with additional evidence once my medical report comes back or once the police report's available, stuff like that.
Right.
And then do that. Demand that the HOA act. The HOA better act.
Absolutely.
We covered this in the last episode 4 of 6. This is 5 of 6. We covered this in the last episode.
Right.
They better act, because I promise you assault and battery is a violation of every set of governing documents in the entire state.
And once again, the bad ones might tell you that's a law enforcement business.
Wrong.
No, wrong.
No, they're right.
Well, on
it
that
is.
facet, yes.
Yes, it is a law enforcement
but
business.
you don't get to do this.
It's also your business, buddy
Right.
boy, and you're going to act.
Yeah.
Okay? Every single physical incident entitles you to a civil restraining order.
Right.
So get that restraining order. Now, if that person violates that restraining order by coming onto your property again or physically touching you, they go to jail. Police have to arrest them. So you want that. Okay? So document.
Absolutely.
But act. Police, medical if necessary, letter, and witnesses. Okay? Now, incident logs, photos, video, all that always applies to everything. Documentation, super important. Okay? Again, don't rely on memory. Judges don't want you to describe what happened in general terms. They want to hear what happened. They don't want conclusions. I was assaulted and battered. They don't want to hear that. They want to hear, he grabbed me, punched me in the face, and threw me into my planter, and then I broke the pot when I fell into it, and I have cuts now from the shards of the broken pot. Those are details. That's what a judge needs to act. Okay? The more you give us at MBK Chapman, the more you give us, the better we'll be able to do for you. And the more we'll be able to put that person in their place, which hopefully might be jail. Okay? Nobody has a right to harass you, invade your privacy, batter you or assault you, or defame you. Nobody. And to the extent that a neighbor's behavior rises or crosses a line into any of those behaviors or conduct, it's actionable, and the HOA has to act. In addition to, when applicable, the police and any other authorities, including local government ordinance authorities, for example, if they're violating a code.
By the way, this is needless to say, but people who have the ability or capacity to engage in that kind of a wrongful conduct, they typically have the propensity to repeat and engage in recurring conduct.
They need to be taught a lesson,
right,
so that they know that they're not going to get away with that anymore. Yeah. And that lesson might be it might involve the police, or it might involve money. It might involve the fact that they're writing you a big check. But one way or another, they need to be punished. Okay? And that's what we're here for. I'm Michael Kushner, and this has been HOA Hell, the podcast. If you like this episode, please hit the like button, and please subscribe to our channel if you haven't already done so. If you want to leave a comment, I would love to hear from you. Go ahead and leave a comment. And until next time, please have a wonderful day.